In your government book, we are in Chapter 8, and we're talking about the federal courts and the judicial branch. The judicial branch was set forth in the Constitution under Article 3. And so we're going to go over Article 3, Section 2, which talks about the judicial process. Just remember, judicial means judge process, so you're looking at our courts and our court cases, right? The judicial process, civil, has civil cases and criminal cases. The majority of federal cases are classified in this way. A civil case is one where you have a plaintiff and you have a defendant. The plaintiff is the person, I always think of plaintiff as complaining. The person that is complaining and filing the lawsuit is the plaintiff. And he feels that he's been wronged by a defendant. And the defendant is the person that's named in the suit that needs to defend himself because he's being named as doing something wrong, okay? So, and he's usually defended as seeking to recover something of value like money or monetary compensation or good equivalent treatment or something. The person is seeking to recover that in these civil cases. And civil cases usually involve some dispute over a federal statute, personal injury, property damage, or contract. So that's what the civil case is usually involved. So the difference between criminal cases now are different. And the criminal cases, the government is the plaintiff and is called the prosecution. The prosecution is the government prosecuting someone, right? Because they seek to bring some legal action against a defendant, and this defendant has wronged society by his behavior. And it's usually, these kind of cases usually involve tough issues like narcotics or embezzlement or fraud or larceny or illegal immigration or even on to murder. You know, these are called criminal cases. So we have, again, let's review. We have the civil case. And the civil case is between a plaintiff and a defendant. Someone's been wronged by another person, right? And they call these civil cases. And they involve disputes over federal statute, personal injury, property damage, or contractual cases or something like that. Those are the civil cases. Civil means between civilians. And then, of course, the criminal cases are those that are criminal in nature, and they have a prosecution where the government is prosecuting them because they've done something that was criminal. And these things can be involved in things as narcotics, embezzlement, fraud, larceny, illegal immigration. All these things can be criminal cases, and even murder, right? So we're going to go over the procedure. Here's a picture of a trial, a courtroom proceeding in an American trial here, as you see, as you go to court. Someday you'll probably have to be on a jury and are picked for jury duty, I should say, not necessarily on a jury, and you'll see what the court cases go through in these certain cases. So both civil and criminal cases, they begin with a trial. A trial is an official examination of the available evidence in a court of law. So a trial is examining evidence. So you have that. They begin with a trial and examining evidence. Most federal charges or federal trials that have been charged are heard in a United States District Court. So we're just going to talk about district court in this chapter instead of not going on to other types of courts, because if we did, we would have a long session. So, and it'd be hard to go through even in your book. So we're going to be talking about the United States District Courts and what they go through. The rest of the trials are specific courts, like tax courts or these other kind of courts, and they have they try special cases. But all of the trial is similar in this. So let's go on to the next page. Here's the federal judicial courts. districts and courts, but let's talk about the United States district courts. So the United States district courts, and they are the most active of all of our judicial courts, and they process original jurisdiction. That means not appeal, appealing from another court. So they have original. There's two different kinds of jurisdiction. They have original jurisdiction is the right of a court to be the first one to hear that case. And most federal cases originate in the district courts. In fact, 86 of all the original cases of all the federal cases, 360,000 per year, are in the district courts, the federal cases, and original jurisdiction. But there's one federal court for each federal district, but the number of judges may vary to the workload. So we have like 680 judges today for 89 district courts, right? So you have 89 district courts and you have 680 judges. You divide them up, some of them are going to have more than one judge, right? So these are in 50 states and Washington, D.C. So 89 district courts, 50 states, and in Washington, D.C. now, all of these district courts. So when I say original jurisdiction, they mostly have original jurisdiction, but some of them do see appeals from other courts that are appealing to them. That means when they appeal, it means they want to bring forth what they have seen in their court to another level, to appeal it to another court, to look over it. So juries. Let's talk about these juries, because maybe you'll be on a jury sometime. Article 3, Section 2 talks about that citizens in our country are guaranteed to have trial by jury in the federal courts. They're guaranteed this. So they're guaranteed the right to have in our Constitution to have a trial by jury. The only exception would be in the impeachment of federal officials, and that's done by the Senate. So all the rest have to go through our federal court system, right? District courts have two types of juries. This is really important to know. There's two types of juries. In criminal cases, two types of juries. You can have the grand jury and the trial jury. So grand jury says district courts are two types: grand juries in criminal cases, grand juries of 13 to 23 people on the grand juries. It's assembled to examine the evidence presented by the prosecutor to determine whether it is sufficient evidence against the accused to try a case. So a grand jury, when I talk about a grand jury, is not a trial. It's basically they're looking at evidence. So a grand jury comes in, 13 to 23 people come in, and then they look over all of the evidence. The evidence is shown them, more evidence is shown them. And so as they look over the evidence, they have to decide whether there's enough evidence to present a trial, right? If there's sufficient evidence to warrant a trial, they'll issue an indictment. What indictment is a formal accusation against the accused. So if they have enough evidence, they say, okay, we're going to indict them. We're going to indict them. We're going to put forth a formal accusation against them because there's enough evidence. And then if the jury finds that there's insufficient evidence, there's not enough evidence, then they may hand it down and say you're going to acquittal. Acquittal, which the accused is immediately set free. If you're acquitted, then you're done. You've been acquitted. There's not enough evidence for you to go to trial. So you got that? So when you think of a grand jury, I always think of a grand jury as this big jury set forth in a trial. It's not. The grand jury of 13 to 23 people is just examining evidence to see if there's enough evidence to go to trial. And then if there is, they give them an indictment. So you're indicted, you have to go to trial. If you're acquitted, then you can go home. So here's a picture of all the federal judicial districts and courts. So again, remember we have how many districts? 89 districts in 50 states there with 680 judges. So some of them have more than one judge in each one. These are districts. So we can see the larger districts in the numbers here. So anyway, here we go. These are the districts and circuit courts listed. So federal and judicial circuit districts. So let's go on to the next page. Now we went over the grand jury. Let's go over the trial jury. It's different types of jury. Trial jury has less members, 6 to 12 jurors. You can be picked to put a trial jury usually goes on and on. So if you're in the grand jury, you're going to look at sufficient evidence. But now if you're in a trial jury, the grand jury, remember, is 13 to 23 people, so there's a lot of people there. A trial jury is only 6 to 12 jurors. And they're from the federal districts. They've been picked. And they're actually hear the case. The trial juries, you're hearing the case in the court. And after hearing the case, the jury then decides whether it's a verdict of guilty or not guilty. Or you can have what's called a hung jury. What's a hung jury? It's a jury that cannot agree on a verdict. The jury is so divided they cannot agree. The jury is a hung jury and they have to do the jury over again. They do the trial over again. So a trial jury, let's review, has 6 to 12 jurors in the federal courts, and it hears the case in the court, gives a verdict of guilty or not guilty, or it couldn't be a hung jury when they can't decide. So the right of the individual to you is to be able to have both a grand jury and a trial jury if needed. In the federal criminal cases is protected by the 5th and 6th Amendment. So the 5th and 6th Amendment of the Constitution basically says that the right of trial in a federal case involving more than $20 is guaranteed by the 7th Amendment. So basically saying, okay, let's read that again. The right of the individual to both a grand jury and a trial jury in criminal cases is protected by the 5th and 6th Amendment, and the right to a trial by jury in a federal civil case, so it's a different case, not a criminal case, has to be involved more than $20. Now we think $20 isn't very much, but back then $20 was a lot of money to them. So, and it's guaranteed by the 7th Amendment. So go back to those amendments, and we're going to go over those amendments in the next chapter. But the 5th and 6th Amendment says we have in a criminal case, if you are presented with a criminal case, an indictment or such, you have the right to go first through the grand jury, which says is there enough evidence, and then on to a trial by jury. But in a civil case, the case has to involve more than $20. So a civil case is between two different people that have been usually to do with money. It has to be more than $20, which most of the time is pretty easy these days. $20 is not too much now these days. So evidence. Evidence. Evidence, what is evidence? Evidence is the material presented as proof at a trial. That's the evidence, right? It can be a lot of different things. The jurors hear this case and they listen to the presentation of evidence. So there's different types of evidence. What kinds of types of evidence are there? Evidence, number one, let's see, there's like three different types at least. Direct evidence. Direct evidence is someone who witnessed it. They're giving their testimony and they were a witness. That's direct evidence. Circumstantial evidence are conclusions that are deducted from facts. So basically these conclusions are deducted from these facts, or these evidential facts. They're not direct evidence. And then there's demonstrative evidence, and this involves objects that relate to the case, like fingerprints or DNA, that kind of stuff. Those are demonstrative evidence, or demonstrative or demonstrative evidence. Like We got their fingerprints, we got their DNA. So those are the 3 times. Direct evidence is a person who witnessed is a witness. Circumstantial is deducting from certain facts. And then demonstrative is involves objects that relate to the case, such as a gun with fingerprints or DNA, that kind of stuff. Okay? Rules of evidence. Okay. What are we talking about? Rules of evidence. It means that the attorneys, the lawyers, must follow a set of standards that govern the admission of evidence into the court proceedings. And these are called rules. They have to go by certain rules of evidence. So these rules of evidence are pretty important. Attorneys must follow these standards. The lawyers must, or they'll be overruled. And this governs the evidence that they can bring into court. They can't just bring any evidence in court. So the exclusionary rule means that evidence must be obtained legally, not illegally. So they have to obtain their evidence legally. This whole thing is based on the 4th Amendment. What does the 4th Amendment of the Constitution say? There's a prohibition of unreasonable searches and seizures. So if the evidence came through not legally, that someone went in and just took an object, went in and searched and seized an object illegally, it cannot be evidence. This is pretty big. And so, this happened in the Supreme Court case called Mapp versus Ohio in 1961. Is basically that they had evidence, but the police did not obtain the evidence legally. They did not get a search warrant to get it, and they just went in and took the evidence. And so they wouldn't let the evidence in court. So the rules of evidence means that that basically the evidence has been obtained legally, not illegally. So the rules of evidence basically are those rules to make determinations whether they will allow certain types of evidence to be part of the trial. So evidence cannot be part of the trial if the evidence is obtained illegally. Got that? Okay. The procedure in the appeals court. So procedure in the appeal. What's appeal? Appeal is basically when the losing party in a federal court, they can then appeal the court to a higher court to see if the court really did a good job or they did everything legally, right? When I say did a good job, that means that they had to do everything legally. It is a request that the higher court review the case and the verdict, of the lower court. So the higher court's looking to the lower court and reviewing the whole case to see if they did everything the way they were supposed to do it, right? Most of the appeals go to the United States Court of Appeals first. They don't go straightly to the Supreme Court. They go to the Court of Appeals. In 1891, Congress created the Appellate Court, or the Court of Appeals, to handle. There were so many appeals, so many court appeals. There was a big backload of them. You can imagine how many appeals they had before the Supreme Court. So they'd say, they'll go to the Court of Appeals first, and then if that appeals the Court of Appeals, then they'll go on to the Supreme Court to appeal to the Supreme Court. So Court of Appeals is pretty important because, of course, the Supreme Court would be totally backlogged and they wouldn't be able to do all these court cases. So now we have 11 judicial courts and 12 courts of appeals, one for each in Washington, D.C. So basically the judicial courts, let's go here, there's 11 judicial courts and 12 courts of appeals. And 12 meaning there's one for Washington, D.C. The Court of Appeals handle about 58,000 cases per year. There's 180 judges in 12 courts and one Supreme court justice for each of those 12 courts. Each court have no original jurisdiction in any cases. They're all appellant courts. They're coming from another court is appealing to them. They have appellant jurisdiction, the right of a court to review the ruling of a lower court. They review the rulings of the lower court. So here we're talking about the Court of Appeals handling about 58,000 cases per year, and having those cases, 180 judges with 12 courts in the midst of all this. And so you can see, for example, the Court of Appeals for the Second Circuit comprises 3 states. You see Vermont, Connecticut. They have, so that district is Vermont, Connecticut, and New York. So it depends on what districts you are, but those Court of Appeals. So the appellant jurisdiction, again, is the right of a court to review the ruling of a lower court. So let's go on here and talk about Congress has given the appeals court jurisdiction in 2 areas. First of all, appeals from the federal district courts. Any federal district court can appeal to these appellant courts. And number 2, appeals from the administrative agencies in Washington, D.C. that most arise in Washington, D.C. So in Washington, D.C., it has the most powerful court in all of the United States because it's hearing all of these regulatory agencies of the bureaucracy in this. So it's hearing a lot, and so it regulates the regulators. Remember we talked about the bureaucracy and the regulators. So the Congress first, again, this review has takes all the Congress has given the appeals court jurisdiction to appeal for all the appeals from the federal courts and also from the appeals from these regulatory agencies, of the bureaucracy when they are charging a regulatory agency. And this is in Washington, D.C. So in Washington, D.C., it's the most powerful court because it regulates the regulators. So those are 2 different things. They take the appeals from the district courts, and then they take appeals from the regulating regulators, the bureaucracy. At a court of appeals, there are no trials, no juries, there are no trials, juries, or examination of evidence. That's not there. It's not a grand jury. So the attorneys submit what's called briefs. These briefs, the lawyers have written and told about the whole court that's already went on. The trial already went on, but they're appealing. And so they go and bring their briefs in, with their lawyers' written agreements in, and the attorneys then have an opportunity to present their oral arguments before the judges. So they go before the judges and present why, they should be appealed to the next court. So the Court of Appeals. So to see whether, basically looking over the trial, looking all over everything that happened and the evidence and everything that was there, through the trial, to see if they actually did everything legally, right? So the attorneys submit these briefs, and these briefs are brought before, and oral arguments. They have to get up and orally presented by the lawyers, and precedents. They go by the law and also precedents. Precedents are past decisions involving similar cases. So they'll look at the precedents like, this is what they did in this case of appeal. This they did in this case. And a lot of times those past decisions and precedents are very important to follow up whether this case could be appealed to the next court, right? They're not retrying the cases, but reviewing the lower court's proceedings to determine whether they followed the law while trying the case. If it's reasonable, they can affirm or uphold the court's decision that was made, or if they think they made an error in the court made an error, they can reverse the decision of the lower court. So when you appeal to the court, your decision can be appealed. Appellate court can repeal and change the decision. If they had a guilty verdict, they can change the decision if it was not done rightly. So that's what appeals are. So if a person or party loses in an appellate court, it can appeal then to the Supreme Court. So say they go through the district court, then they go to the appellate court, and then they want to appeal, they can appeal to the Supreme Court. But this is very, very rare because the Supreme Court does not take a lot of cases, a lot of appeals. So the Supreme Court is the highest level of appellate court in our country. So we can go all the way to the Supreme Court. In some cases do, not very many though. So let's go over some of these questions to review. Section 2 review says, what is a civil case? How does a criminal case differ from a civil case? So a civil case is where you have a plaintiff and a defendant, and the plaintiff is seeking to recover something of value or something that happened from the defendant who's defending themselves, right? A lot of times this is property damage, personal injury, these kind of things happen in the civil cases. A criminal case is different because the government is the prosecutor. The government is the plaintiff, and the government seeks to bring some legal action against a defendant that has wronged society in some behavior, So a lot of times those cases are have to do with drugs that going on to, from that, any type of criminal activity, right? So number 2, where do most federal cases originate? Most federal cases originate in the district courts, right? That's where they start. Like 86% of them have original jurisdiction. Number 3, what does a grand jury determine concerning a court case? A grand jury determines whether there's enough evidence to do the case. So basically, a grand jury determines whether they'll be indicted. That means there is enough evidence, or they'll be acquitted. There's not enough evidence. So they're basically looking at the evidence, if there's a sufficient evidence to go on to try the case. Okay, number 4, explain a trial jury's role in a court case. So basically, the trial jury, if you're on a trial jury, you're going to hear the case. You're going to hear basically the lawyers of each case. That's the case we usually see on TV. And a trial jury will issue a verdict of guilty or not guilty, or it may be a hung jury, which says number 5 is, what is a hung jury? A hung jury is a jury that cannot agree on a verdict. They're hung. They're divided. So number 6, what is trial evidence and what are the rules of evidence? Explain the exclusionary rule. So trial evidence, or the material that's presented as proof in the trial, right? And the rules of evidence set the standards for the lawyers on what rules they must follow in bringing in this evidence. The exclusionary rule says that if you obtained your evidence illegally, that you just went and got this, took without a search warrant maybe, that kind. Sometimes police they take the evidence, they didn't go through the evidence correctly. Correctly means, okay, they go in, maybe they just grab some of it. You can't do that. The fingerprints and the surrounding evidence is very important. So the evidence has to be obtained legally. If not, it's going to be excluded. That's the exclusionary rule. Number 7, what is an appeal? Well, appeal is a request to go to a higher court. You have a verdict of guilty, and you feel like the court didn't do you well, so you can appeal to a higher court, and that court will review the case records to see if the lower court did what they were supposed to do, right? So what courts handle the appeals from the federal courts? They're held, the courts that handle the federal courts are the United States Court of Appeals. Basically very easy. United States Court of Appeals handles the appeals, right? So what courts handle the appeals from federal courts? Well, that's the United States Court of Appeals, sorry. What does a appeal court determine in reviewing the case of a lower court? To determine whether the court followed the law while trying the case or not. Or they either can affirm and say, yes, the court did well, or they can reverse the decision of the court if they feel the court didn't do well or didn't do what they were supposed to do legally, right? So, okay. And then the last section, we'll be done with the whole judicial system. And here we're going to talk about what? The Supreme Court. Here's a list of all the Supreme Court justices from 1789 till 2005. Now we even have more. So, but anyway, we're going to go on the next section with the Supreme Court.